127. Fundamentally, however, I dismiss the plaintiff's amended summons because I am not satisfied to the requisite high degree of probability about the risk the defendant poses, and I cannot conclude that he represents an, open quote, unacceptable risk, close quote, of committing a serious terrorism offence if not kept under supervision under the proposed ISO or ESO. Orders 128. I make the following orders. 1. Amended summons dismissed. 2. Plaintiff to pay the defendant's costs. So we can see this want to further impact onto the defendant has been quashed, it's stopped. We also see that the justice uses some words in 126. I also doubt that the type of activities the defendant might engage in, even if he was still a, open quote, believer, close quote, would properly considered amount to a serious terrorism offence. Believer, belief, beliefs. And we get back to delusion, delusional beliefs, recalibration of his delusions, did not believe those things anymore, used drugs to stop him from believing those things as an intervention. There is so much in this document that points to not only torture at a technical level, but we go beyond torture into forced medical procedure. We go into medical intervention and some seriously nasty connections to forensic psychology and the justice system. It could be said that forensic psychology should be shut down. It's quackery. It could also be said that forensic mental health within those jail systems should be shut down, and all of that health should be brought under the auspices of the Department of Health of New South Wales, and all those prisoners should be treated exactly the same, with the same responsibilities and liabilities of Health New South Wales. What can be seen here is a direct issue that reflects why the Attorney General of New South Wales is in the back foot in response to the United Nations inspectors coming to visit New South Wales facilities, corrections facilities in particular, wherein these forensic mental health facilities exist, because they don't exist in the hospitals. Well, they might within the boundaries of those mental health doorways, but in general they don't exist under the Department of Health. There is an overly serious offence that has been committed here, and it needs to be addressed, because this is happening to people every single day. This is happening to people every single day. When the justice is leaving these trails of evidence on the table, it's being done for a specific reason, in that what is not a mental health problem becomes a mental health problem because of the sheer intervention by these forensic mental health agents. That they have made up the quackery And in some of these occasions made up this quackery just based upon paper reports. So having no physical interaction or legal discussion with any of them. And what can be proven here is there is a grave ignorance in many of these doctors. It's easier to shut up than have to answer to all of this stuff because they don't want to listen to your answers. That's a sad truth. And that they can't deny this because they put me through exactly the same thing for being in a jail over recording in a courtroom. And no civil libertarians stood up then. No one said, "Hey, what's going on? Why would he be doing that? Why is he going to jail for that?" No one looked at anything back then. And here you have a justice, in the justice's words, stating the type of activities believer, not terrorist, not terrorism activity, curial versus something else. This puts them in a position which would bring something else to the fore. Right, this sort of closes the documents at the end notes, and then at the final end of the page there are some referenced citations. These are the court cases that were referenced within the text above. Legislation cited by this decision. The Constitution of Australia, 1 citation. The Criminal Code Act 1995, Commonwealth, 11 citations. Firearms Act 1996, New South Wales, 1 citation. Terrorism High Risk Offenders Act 2017, New South Wales, 37 citations. Note, New South Wales, 1 citation. So all the other citations to all the other acts, and this one act has 37 citations. I can't stress this enough. The United Nations came to New South Wales and said, "Let me in," and New South Wales said, "No, we don't want to let you in," and the United Nations requested through the federal government and then left. This is important because now, on the books, New South Wales have demonstrated that it don't want to play by international rules. And now they've been put in the hot seat by their very own actions and the actions of their New South Wales police. Well, I can't stress that enough. It's all in front of you. These agents, doctors, police officers, and in many ways the Justice Department have created this situation, and the Attorney General of New South Wales has a bit of an issue on his hands in relation to this situation, given that what I've laid out, without shadow of a doubt, is a deterrent. The drugging was used as a deterrent to stop him from having beliefs in something that may put the state into an accountability mode.